you're using. I have 2 dictionaries here. Sorry, Ruth. Where's the other one? Yeah, concise.
Before the court to maybe check the dictionary, I rise on behalf of Mr. Mngomezulu. He is asked to address the court to retract what was said earlier.
To retract what?
What was said earlier.
Me, I must retract?
No. He wants to retract what was said earlier.
No, he'll do it if he wants to, but I'm going to read for him the words he used. That's why I tell him that he doesn't even understand the word collusion. Doesn't, obviously.
Ms. Mokula Malote just asked me to explain to her what is the meaning of the word surreptitious.
Who was?
Senzo Meyiwa. Yeah, she said yesterday I used the word. I can't even remember when I used that word. I don't know where it came from. Yes, she's here.
Can help me.
Wait, madam, I'm sorry, out of record. That is out of record. Yes.
No, there's not of the record. That's what every man in South Africa, any woman in South Africa, hears and sees what the record.
Yes.
I even went off the record.
Now, the way it arose in the context of the proposition that was put by the Nisi to Colonel Holmes, that yes, that the police committed an irregularity when they did not search accused number 2.
Yeah.
We then objected and said, but there are no. It can never be an irregularity to fail to search and accuse. Then our Nisi then said the state is surreptitiously suggesting an answer to and I understand the word surreptitious to mean underhand, stealthily, in a covert, covert manner.
Yeah.
If that
I think Sergeant Mukolakole answered. I think Sergeant Mukolakole answered.
In an improper way, in a sense that she mustn't be aware what is happening. Okay, just going to give you the meaning of the word used. This is the South African Concise Oxford Dictionary. This is the fourth edition, 2005. This is what the word collusion means. they start with the relative of the word collude. Come means come to a secret understanding, conspire, have a secret agreement, or a secret or illegal cooperation in order to cheat or deceive others. That's what they say. Now this is also the modern Oxford Dictionary, which is the shorter version. Collusion. Secret agreement or understanding for nefarious purposes. Conspiracy, fraud, trickery. An agreement between two or more people, especially ostensible or potentially sweet, to act to the prejudice of the third party or for improper purpose. Kedu is the one we quote his judgment, me and you. He has defined in the case, you will read it for yourself. In the case of Cleveland versus Cleveland and Ward, 1908 TH 197. It says it's an agreement or mutual understanding between the parties that the one shall commit or pretend to commit an act in order that the other may obtain a remedy at law as for a real injury. You can also read this case of Gabriel versus Gabriel 1945, and you can also read McLean, this is McLean 1923, etc. Now you are saying I'm a cheat for nefarious reasons. I'm colluding. I've taken an oath. If you don't know, to administer the laws and the Constitution without fear, favor, or prejudice, and to the best of my ability. I don't know Mr. Valui from a bar of some. It's the first time I met him here. I've never ever had a private conversation with this gentleman. Never. You can ask him. When I talk to him is when you come together and I see him in my chambers. Now I'm told I'm colluding on a useless thing like an affidavit, which you say you're no longer interested in. And look at the position of a judge like me. This gentleman says, I have made an affidavit, and in the affidavit I've spoken about the two cell phones. He says, no, I'm no longer interested in them. This court, what must I do? Sit. What is the answer? I've got to say, where's the affidavit? Because I want to know whether he is telling the truth that he wrote an affidavit on the same day in which the telephones, two cell phones were picked up. Then you're saying me, I send him into the arena. He's sending into the arena. What for? We don't want to say anything about it. That's why.
May I address the
No, please don't. Please. I took advice from the JP now. I told you I won't do it. Okay, Mr. Shalom. Let's hear you.
One question for you. Were you present when your statement, this statement, was commissioned?
Well, the statement, sir, for this statement is a commission. No.
Okay. Yes, Mr. Baroi.
As the court pleases the Lord. Constable Mngomezulu, Constable Viteles, I'm sorry. It was put to you this morning by Mr. Mngomezulu that you were coached outside the courtroom and that no cell phone were taken from accused number one.
So I moved to this other and cell phone here to
kushiwo njalo, yes, kwasiwe kanjalo.
Yes, that was what was said. That was how I was indicated.
My Lord, we seek permission to refer to what was said in the trial within a trial. Normally, such evidence is insulated from the main trial. However, the reason why we want to refer to it is twofold. Firstly, my colleagues have already freely referred to such evidence. But secondly, my Lord, and more importantly, a version has been put which substantially detracts from what was said in the trial within a trial. We are of the view, my Lord, that where the issue of credibility has been raised by the accused himself through his legal representative, then that issue of credibility should be threshed out. And we briefly want to refer to the case of State versus Muchindu, the judgment that the court has already referred to of Schutz J, 2000, volume 2, SACR 313, at page 317, paragraph F, where the court said the following: some mention was made of the question whether, even if the accused evidence in the trial within the trial may not be produced in the main trial, it may be used to cross-examine him if he offers a different version in the main trial. Here, my Lord, it's not being used to cross-examine the accused, but just to show the discrepancy, a serious discrepancy, and which has led to my colleague maligning the witness. Further on, the court held that the majority of the Privy Council answered the question affirmatively in Wong Kem Ming case at 258 to 260, and the judge refers to, so in the UK, my Lord, the court says if credibility is at stake, then the version that has been proffered in the trial, within a trial, can be referred to in the main trial. Then the court went on to hold that the appellate division left it open in Sitebe's case. It says more recently it was answered affirmatively by the Transkei Appellate Division in a tribunal in State versus Sabisa 1993 volume 2 SACR 525. In that case, it was said that if the accused departs from...
I think my concern is that I'm not so sure whether what
Doesn't he have to finish first and so finish? Doesn't your colleague have to finish first what he's saying?
that is the purpose for an objection.
You can't do that. You know the procedure.
That is the purpose for an objection.
No, the objection, he finishes first. Then you tell him the objection. He hasn't even finished what he's saying. He's trying to quote this case of Silisa.
Which is the reason why, because in terms of procedure, it does not need to finish and to object first before he finishes.
Please, just sit down. That's not the procedure.
Thank you.
As a this,
You can object the whole day, but you got to listen to a person until he finishes whatever he wants to say. Then you object.
But
I've read the case of
that's
war.
what the state could do.
Let me
When
tell
you
you.
put something,
No, but I read the case of
even before
war.
we finish, then the state will also object. And that will be good for the
No,
state.
no. I say I've read the case of Wong. The Kensrich calls it in the state versus Zuma. Okay.
Then in this case of Michindu, the court left the question open. Then we refer to this case of Sabisa, 1993, volume 2, SSCR 525, and the bench, amongst others, consisted of the former Chief Justice of Zimbabwe, Judge Mngomezulu. Then it was also the Chief Justice Beck and Golden J.A. At page 525, paragraph G to H, the following was held. Although it is wrong for the prosecution to cross-examine the accused during a trial within a trial on the merits of the main case in order to establish that the accused is not a credible witness, and this is the most important part, where the accused chooses once again to lead evidence during the trial on the merits which he led during the trial within a trial, he may lay himself open to cross-examination in order to establish credibility or otherwise. As we indicated, my lord, this is not about cross-examination, but it's about quoting passages in the trial within a trial that would counter the very serious allegation that was leveled against this witness. And as I indicated, my lord, my colleagues who accused 1 and 2 have freely referred to the evidence in the main trial. We just want to refer to
What allegations have they?
two pages that counsel for accused number 1 has put it to Constable Butelezi.
Oh, yes.
That he was coached outside the courtroom, that that no cell phone were taken. In fact, it was even put that he's cooking, and these passages are just simply intended to show that what is being put to the witness is unfair.
Yes, Mr. Williams. What's your response? Who's coaching him, you or me?
Well, it wasn't specified. It just said he was just coached outside the court.
Okay.
First, my daughter was not even aware that the constitutional changes will take a stand. I was under the impression that my colleague Advocate Minister was going to complete this first examination. Number 2, I heard from my colleague Mr. Ransikin that they are calling changes, but there was no mention that they are calling the police officer. The Chinese they are calling is the one that sent money for dance. I was under the impression. To my surprise, hence when I stood up, I objected to the evidence of the calling of Constable Chinese, but I considered when the procedure was properly followed that he was a candidate to be led in the retrial. But my lord, the fact that I made such allegations or assertions to the witness is because some of the things that I said to the witness were said to Sergeant Mkola, and they were not taken up as seriously as the state is now and taking such submissions as even the issue of cooking was addressed to, was canvassed to Colonel Coase on the basis that when you made a statement, you referred to one statement, one cell phone. And when I cross-examined Sergeant Paula, she then talked about there's 2 cell phones. And I asked her why such cell phones were not mentioned during the trial. So, soon thereafter, Colonel Holmes made a supplementary affidavit. In the first affidavit, he mentioned only one cell phone, which is 079-379-37-0137. So on the supplementary affidavits, there are 2 cell phones that are mentioned. The one with 060 and the other one with 071. I also canvassed it with Sergeant Paula to the extent.
Sorry to interject, but Mr. Arui is concerned about the base used, not about the innards of what you said. It just takes exception that you are saying to him, he coached this witness. Am I quoting correctly? That's what that's what your learned colleague feels, that his dignity is impugned.
No, I don't get me just. If I was properly understood, I said I was not told that Constable Davis was going to testify.
No, that's not the issue.
Yeah.
You're saying he was coached outside the passage. You said that.
But I never specified to say he was coached by.
Okay, fine.
I never specified
Fine.
any name. I just put it
And then the other stories about this gentleman being told that you are not talking about traffic tickets.
Now, may I withdraw that one? I wanted to withdraw it to apologize and say I wasn't supposed to say that. Because I didn't want to justify what you said, which invited me to say such words.
No, but you are used to saying this. Everybody is cooking the evidence. Even this judge is siding with, the prosecution and colliding with the court. I don't know, you want to be accepting me with section 317. Let me read it to you. You can sit down. Because you are not addressing the language you used against your colleague, Mr. Arui. You are saying now, you never mentioned anybody by name. I don't know. Maybe Nelson Mandela will wake up from his grave and coach this witness. Because anybody knows you are referring to the state.
No, that's an inference.
Yeah.
I never.
The only reasonable inference. Only. The only person who's using evidence on behalf of the state is Ibande and
the investigating team, my lord, is not the persons that you can corroborate. No, I'm not making a reference to this record. May I not be misquoted? I said that they can pay that on record. I never paid.
Even you were going to say one day to the others, you never said I'm colluding.
My lord, you once made mistakes and you apologized.
Yeah.
But now
But I don't swear at anybody.
No, but I made mistakes.
You're swearing at me.
And
you're calling me a cheat. You're calling me a nefarious character.
But my lord, you never afforded me an opportunity to retract and to apologize.
There's 317. You can't let him be with this 317. Let me tell you what it says. Section 317, special entry of irregularity or illegality. 1. If an accused is of the view that any of the proceedings in connection with or during his or her trial before a high court are irregular or not in accordance to law, he or she may, either during his or her trial or within a period of 14 days after his conviction, or within such extended period as made upon application in this section referred to as the application for condonation, on good cause, be allowed. And stating with respect that the proceedings as alleged are regular or not according to law, then such a special entry shall upon the application of such a special entry be made unless the court to which the judge to whom the application for a special entry is made is of the opinion that the application is not made bona fide, or that it is frivolous or absurd, or that the granting of the application would be an abuse of the process of court. So you can make it. I can tell you, in my 22 years on the bench, nobody has ever succeeded with an entry in terms of section 317, ever. Not this judge. Okay, you can make it anytime. That I'm wrong on the law. I said this and this and that and that and that. I still want to see me being wrong on the law. That's said. Are you still going on?
I think